Hey again, everyone. It's Rob Ryder. A couple of different things we're going to talk about today. The one that affects everybody is this unauthorized in any other name, which really has to do with attorneys who are not using the name they have registered as an attorney when they do things as an attorney. And so the attorney isn't doing it, right? An unauthorized person is doing it. And we'll get into more of that in just a second. And then so because this is unauthorized practice of law, you find that they have that has its own section of things you're supposed to do to point it out, other than just go directly to the Attorney Grievance Commission to say it's official misconduct. You need to go to another place and say it's the unauthorized practice of law. That's what it appears like, and we'll find out. But I'm pointing this out so that people that are out there that want to try things, here's something that needs to be tried, and it is being tried now. But one or two people doing it isn't enough. We need others to get up off the couch and go try something, because you're just doing what the law says to do. So you're not going to get in trouble for it, right? If that's your fear, well then dig a bunker and go count your ammo. Otherwise, get in the game. God's calling on you. So the other thing I want to do is, so this is one thing you could do. Another one is, well, you could put a complaint into the United Nations, for instance. They have a human rights violation, and because the attorney's not using the name on the paperwork, and the whole thing is a simulated legal process, using, what's called color of law, well, that is an international crime against humanity. Because they don't want you to be in your proper person. That's why if you look at the docket, you're Rytlewski, Robert Allen, not Robert Allen Rytlewski. They don't want to sue you in your proper name. They won't sue you in your proper name. Well, that is the enforced disappearance of your person, of your proper persona. That is a human rights violation. And so I filed a complaint with the United Nations this week, and I don't know what's going to come of it, but I like to put, after I do these kind of things, to put it on the air as a public record. And then I have another one I'm not quite done with, but will be shortly, and send it today. And that's to a bunch of Catholic attorneys, playing on their conscience, letting them know, man, this is what you're involved in is how a Christian would take the widow's house. Right? You're violating the Bible. So, without any further ado, let's just start reading and see where it goes. And one of the many things I read, it said a lawyer's name on the roll will reflect the name under which the lawyer was admitted to practice of law in Illinois, or any subsequent name change allowed by the court. So they have this thing, it's called the roll of attorneys, and whatever name is on there is the name that the lawyer can use as a lawyer. If he uses something else, he's not doing it as a lawyer. For example, right, Robert Allen Rytlewski, right? That's my full name. That's what I would have on this roll of attorneys. But what you find an attorney doing, who if he is attorney and he could get a certificate of good standing or these other things, he's on the roll of attorneys, because I don't even believe that they all are. They just, they act like they're attorneys. So these are the things that we test them on. You say you're an attorney, I want to see your certificate of good standing from the Supreme Court. And if he can produce one, it's going to be in his, proper name. But if you look at the paperwork he's been putting in, he's going to be doing it as like Robert A. Rytlewski, without the middle name. It won't be in the full name. Well, Robert A. Rytlewski isn't the name on the license, and therefore the roll will reflect the name under which the lawyer was admitted to practice of law. They're looking for the full name. And Bobby in Arizona proved this because he called the clerk's office asking if a guy who is the assistant city attorney if he was on the roll of attorneys. And so he gave her the name, and I think it had a middle initial, and they came back and said, no, that name's not on a roll of attorneys. And Bob said, are you sure? I'm looking at the Surprise City website, and it says right here he's the assistant city attorney. Can you go look again? Come back? Nope, he's not. We suggest you call, and whoever it was to call. And it was like the grievance commission. And that got kind of put on the side burner because we were trying it with Bob's case to go also to the city manager, because he's the top law enforcement man, and point out the fact that, in things I've already done other videos on, that the forms they use aren't the forms that have been approved to be used in court. Right? They've adulterated forms that were approved by the Supreme Court to be used for a traffic ticket. And it isn't that they can't change it, but if they do, there's a procedure they're supposed to go, which means there's a paper trail, and it was very clearly laid out in Arizona. And you call that office, and they don't have any paper and anybody. They ain't been able to produce a damn piece of paper yet. And yet, the one that Surprise City in Arizona is using is different than the one that the Supreme Court has said is the one to be used. Unless you have something from them saying you could change yours. And they don't. Well, that in itself makes it the direct criminal contempt of the highest court of the state. Done by the prosecutor, in the case of a traffic ticket, right, who's an attorney at law, who he isn't using his proper name. He's not using the name on his law license. And so there's all sorts of shit that happens. It's a mess at the beginning, and that's where it should be. And it gets messier as it goes on. But as Lord Coke said back in the 1600s in the Institutus of the Laws England, point out their error early and see their last. Right? So we're looking for something to happen early, and the first thing to happen is the guy didn't sign the paper right. He's not doing it as an attorney. Doesn't matter what he put in. He didn't do it right. So he really didn't put any paper in. What he did is he brought fraud upon the court and is in direct criminal contempt of a court by the unauthorized practice of law. Blah, 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 blah. Right? So now, what do we do with that? Yeah, that's what you have, so what are you supposed to do with it? And that's what we're going to see is, where are you supposed to take these kind of things? And if you're going to make that the issue, how do you make it the issue? Now, on top of what Lord Coke said, then Lord Blackstone in the 1700s said, point out their error. No, that was Lord Coke. He said, basically, one of the first things you do is ask by what authority do they bring this charge? I've known that for a long time, but it's like, well, what does that exactly mean? Duh. Well, yeah, they got to be doing it. If they want to be the attorney, bring in the charge, they better be an attorney licensed to practice law, and that's a particular name, and if that isn't the name that's on the paper, they didn't do it as an attorney. So they don't have any authority. And it goes the same with the law enforcement who gave you the ticket. If he's not a peace officer who's under oath, bond, badged, yada, 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 a state officer, he cannot arrest you. Only a peace officer can arrest you. The other guys could assist a peace officer, but there has to be a peace officer involved, so he's got to do the paperwork. So when you look at your ticket, there better be a peace officer's name on there. And again, full name, the name that's on their oath. I'm going to step back from that because they do oaths with the middle initial, and that could be incorrect. So, however, in their full name. Right? Trooper Smith isn't a person. Trooper Smith is like a title. You got to have their full name on there. And then if they don't do these things, then they're supposed to go before the magistrate to swear out the complaint, and they don't do that either, so there is no sworn complaint, so you just stepped into a simulated legal process using color of law. That's a human rights violation, and you can take it to the UN. But we're not quite there yet, so let's go on. So this is so what we're talking about is a thing called improperia persona. I like to say proper persona, but that's incorrect. It's propria persona. And this is in the definition of improperia persona on the legal dictionary you find on Google. The U.S. Supreme Court observed in a unanimous decision in K versus somebody that a lawmaking body, that would be the legislature, may instead prefer to discourage attorneys from appearing in their proper person. What? May discourage attorneys from appearing in their proper person, and the proper person is the name that's on the attorney's license. So they're telling them not to appear as an attorney. Because such self-representation may often conflict with the general public and legislative policy favoring the effective and successful prosecution of meritorious claims. Aren't they so nice? What's a meritorious mean? It means earning money. Successful prosecution of earning money claims. Right? You're not there for justice, you're there to earn money. And if you come in your proper person, well, you just came as an attorney and now you're bound by your oath and all these rules they have on you, right? But brother, just use the middle initial and go in there and you can, now you can do as you please. Now he's going to get you to sign a piece of paper to give him power of attorney just like you gave it to your grandma. To anybody. It's just a power of attorney. They're going to represent you. They're not going to give you legal advice. If he came in proper person as an attorney, licensed to practice law, he would be there to give you legal advice, not to represent you. You would both be there. It's your case and he's giving you legal advice. Instead of what normally happens in a court case, especially criminal, is, right, you don't get to talk. It's the frickin' attorney that does all the talking. Or even in a civil case, they don't listen to a word you're saying, because you haven't done something right. Blah, 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 blah. Anyways, the Supreme Court said in this case that lawmaking body may instead prefer to discourage attorneys from electing to appear as attorneys, because such self-representation may often conflict with the general public and legislative policy favoring the effective and successful prosecution, right? So the idea is to win for the prosecution to win earning money claims. And what's an earning money claim? It's when your plaintiff says, look, you win this, I give you 20%. I don't care how you do it. Hey, I handle it from there. The High Court observed that even a skilled lawyer who represents himself is at a disadvantage in contested litigation. Well, now here's another thing. Most of the litigation that you're involved in is not contested. It is an in rem property hearing where they're going to issue in rem judgments. And that's to determine who owns the property. And they're not, and while they could do it in proper persona, because to do it in rem, they're doing it under ambulatory jurisdiction. And ambulatory jurisdiction in a state court is done under statute law. Yada, yada, yada. They're not signing any of that paperwork. They're long past doing any of that. They don't do any of that stuff because they're not coming as an attorney at all. So they're not following any rules. Right? They have all the shit written they could do. And if they did that, and you were incorrect, well then you would lose. But they don't follow those rules and you're not incorrect because you didn't do the things they said you're doing anyways. They're trying to use a statute as an instrument of fraud, and that is against the equity. What do you call those things? From way back when. You got the something of laws and the something of equities. Can't remember what it is. Maxims of equity. To use a statute as an instrument of fraud is a violation of the maxims of equity. Ethical consideration may make it inappropriate for him to appear as a witness. He is deprived of judgment. This is if he appears in his proper person. He is deprived of the judgment of an independent third party in framing the theory of the case. You're right. He's supposed to be there giving you legal advice, not making his own interpretation of things for his own benefit. Evaluating alternative methods of presenting the evidence instead of just saying, here is the evidence, and see, they didn't sign the paperwork, they the other side, so there is no contract. And that's what happens in your foreclosure. Just go look at your deed of trust, mortgage, whatever you call it. You signed it. The bank never signed it. There was never a contract. If you want more evidence, that's why your money goes to an escrow account. Escrow account's a third party holding the money because the other parties haven't agreed to something yet. And in your whole time of making house payments, you're sending them to the escrow account. Apparently, you don't have a contract with anybody. I guess none of that had anything to do with buying the house. Cross-examining hostile witnesses, formulating legal arguments, yada, yada, yada. So basically they're saying, hey, you want to make money, you can't come as an attorney, because if you come as an attorney, you're going to be bound by your oath. And just like the brother here in Michigan when he had the IRS situation, and he went into court, and the first thing he said to the judge is, I accept your oath, bind you to it, remind you of a fiduciary duty, and extend you my sovereign immunity while you carry out my orders. And the judge's jaw dropped. And the prosecutor put his head in his hands. And the IRS guy sitting there next to the prosecutor, he don't have a clue. He didn't know what was going on. And so the judge looks at our hero and tells him, hey, why don't you go have a seat in that room over there? We'll send this IRS guy in just a minute. A few minutes later, the IRS guy comes in, and he looks a little bit shaken. And he's really trying to figure out what our hero had said to the judge to allow the hero to go sit in a room while the judge told him, paraphrasing now because I don't know exactly what he said, you go in there and you tell him if he signs this piece of paper that you're going to drop the charges or whatever it was. You got to write a letter, some kind of letter. And that's what they told our hero, and apparently he did. But he's never shared what they said, what he was told to put in a letter so other people could use it, and that's always bothered me, but hey, what can I say? Everyone to his own. And he went home. Now, he had gone in under gunpoint. The IRS had come to his house with guns drawn and fucking put him in a car, took him to Bay City to go to federal court. And there they just set another hearing, and when he went in, after we had talked a bit, and he got the idea, I'm going to accept his oath, bind him to it, remind him he has a fiduciary duty, because an oath is a contract with the public. And he's sworn to it. You need to accept it. That's the idea of a contract. Both parties must agree, so accept the contract. I accept your oath. Bind you to it, remind you of a fiduciary duty. It worked with a federal judge. Right? The guy got rid of his IRS problem and went home. But the judge did ask him, is there any other business we need to take care of? And our hero said, no, that will do it. Right? Apparently there could have been more he could have been brought up. Like, I'd like to have access to my estate, judge. Right? Somebody is enforcing the disappearance of my proper person. So, let's go. Okay, so anyways, if you Google unauthorized practice of law, Google, right, this is the first page that comes up, and you'll start seeing all these different things. And so I would suggest you put the name of your state in here and then the unauthorized practice of law, but I had this because I didn't want to forget. So, as we'll see with the unauthorized practice of law, it's different than if you're going to complain about an attorney to the Grievance Commission. This is a different place you're going to send it to. And you can do it to this place, like where it says unauthorized practice of law, State Bar of Michigan. That's the administrative side. But down here, this is a Michigan compiled law, right? This is a criminal code, unauthorized practice of law. And so this is what you would do in the court to bring up unauthorized practice of law. So one way is you go to the administrative side and you put in a complaint to a particular group that's been established to take these complaints, only for one thing, unauthorized practice of law. But if they decide they're not going to prosecute it, then you still have the judicial side, which is this one, except you don't go give the stuff to the frickin' court clerk. Right? You need to file your complaint with the trial court. It didn't say file it with the clerk. It said file it with the trial court. And I believe that means you go sit in open court and you wait for a minute and say, Judge, I got some business for the court whenever you have a minute. You get them in open court. Or you go to the chief judge of the jurisdiction, county, basically, and you go to the old courthouse and you go upstairs on the top floor, you're going to find a room that says the circuit court, and walk in there and say, I got some business for the court. Because that is the circuit court. I don't care if there's nobody in there working. That's the circuit court. It says so above the door. So, cool. Let's go. Where are we going next with this? So, all right. So the name that's on the roll is the name they're supposed to use. That's going to be the full name. What you're going to see on paperwork is like this with an initial. And what you're going to find you as the defendant as is your last name, comma, first name. Right? These second two are legal fictions. Only the first one's your proper person. And that's the one you demand to be seen in. I want to be seen in my proper person. Or they've given you a civil defect. And that's why you need to have an administrator of your estate. What is the unauthorized practice of law? When a person or company says or does something on behalf of another person that involves legal discretion or making a decision about legal matters, that is the practice of law. Legal discretion, making decisions about legal matters, that is pretty straightforward. It is the unauthorized practice of law for a person to exercise legal discretion on behalf of another person or practice law for another person when they are not legally authorized to do so. Well, they're not legally authorized to do so if they're using their middle initial. Now, this is in the District of Columbia. Right? They got a Rule 49, unauthorized practice law. And so every state is going to have, their court's going to have some rule about the unauthorized practice of law. Is my guess, because, one does. If one has it, they all have it. No person shall engage in the practice of law in the District of Columbia. That means in the federal courts also. So this could say no person shall engage in the practice of law in Michigan, or in any manner hold out as authorized competent to practice law in the District in Columbia, District of Columbia, or Michigan, or Ohio, whatever else, unless enrolled as an active member of the District of Columbia Bar, except as otherwise permitted by these rules. Now, this last part may be different, how they say you need to be enrolled into what to be able to do it, but there's a voluntary enrollment by the attorney to be allowed to do this. And so that's how they get on the roll of attorneys. Okay, but this is just a rule about, well, what are we going to do about the unauthorized practice of law? Okay, well, this is, first of all, it says you can't do it. The Committee on the Authorized Practice of Law, known as the Committee on the Unauthorized Practice of Law, consists of 6, not more than 12 members of the bar of this court. I didn't say the District of Columbia bar, I said the bar of this court. Don't know who that is. And of one resident of the District of Columbia who is not a member of the bar. Yada, yada, yada. So, anyways, they set up a special committee. I guess that's all this law is showing. Okay, and now we set up a special committee for this. And here's some of the powers of the committee. To assist the committee in performing its functions, it may take sworn testimony of witnesses and or respondents. The chair may apply to the court, and the court is this is the District of Columbia Court of Appeals. That's the highest court. So even all them federal attorneys over there in the federal side, all are under the District of Columbia Court of Appeals because it has jurisdiction over the practice of law within the District of Columbia, which is the same as a state. So in your state, you have one court that has jurisdiction over the practice of law within the state. And its equivalent in the District of Columbia is the appeals court. The District of Columbia Court of Appeals. So the chair may apply to the court for an issuance of a subpoena. Right? So they're not playing around. You're going to get a subpoena from the highest court in the land. Proceedings before the Court of Appeals. The committee may initiate an original proceeding before the Court of Appeals in violation of this rule. The proceeding shall initiate by petition served on a respondent or his designated counsel. So we're going to find out more about this when we get into the stuff. But first, for me, doing this, right, this is my answer to God's call. 3.5, 4 years ago when my son was in the hospital for the second time in 10 days to have an operation because of a Crohn's condition. And I had my come to Jesus meeting. I said, show me the light. Show me the direction. Tell me what to do. Right? And I'll just go like a freight train. I'm not stopping. And that's where I am today. I've been able to do this almost completely, 24/7 since then. And I want to thank all those who have donated in the past. I don't know why I can, and I don't know why I do, but I can sit here and I can read all day long. I can do it for days on end. I can read the same thing 5, 6 times. It doesn't bother me. I'm going to read it till I understand it. It's just the way I am. And so I'm looking at things a little bit differently, but I'm working really hard at it. I just can't give you the answers yet. But we're getting much closer, and I need to know if you can help support my mission. If you can, the PayPal account, as usual, is Ashley Rytlewski, who's my daughter, ASHLEYRYTLEWSKI @gmail.com. Or use the snail mail and send it to Robert Rytlewski, 10955, 14 Mile Road, Rockford, Michigan, 49341, 8664-55. That's my +11. That'll take you right to your mailbox. And as it turns out, it looks like the courts use their +4 is 0000, which would be the first stop on the post road. Or could be the starting point of the post road. Which means, well, that's where the post office is where the court is. And back in the day, that's where the court was, in the post office. In fact, most federal, probably all federal courts are in post offices. Right? It's the court and post office building. Or usually it's the post office and court building. I mean, the post office is first and then the court. Yeah, just kind of interesting. And today is Wednesday, December 24th, 2014. Have a blessed new Advent, because we're going to have one heck of a year coming up. All right. So, Bro sent an email to the Supreme Court Clerk's office. And she had asked a couple things. Number one, there's supposed to be this fee schedule they keep talking about that nobody wants to give you a copy of. She was asking about that, and then asking about the role of attorneys that they're supposed to keep. And so first she talks about, the fee is 25 cents per page. This is called confession and avoidance. We weren't asking how much it costs per page. We were asking for the fee book that we had found reference to and found in one county, but trying to figure out where it came from. And so they try to, we don't know what you're talking about, and they go someplace else. But then the second one was, further, the role of attorneys who are licensed to practice in the state of Illinois is maintained not by the Clerk's Office of the Supreme Court, but by the Attorney Registration and Disciplinary Commission of Illinois. The list of active judges in the state of Illinois is maintained by the Administrative Office of the Illinois Courts. Now again, this was their answer to Roe asking for the role of attorneys that's supposed to be kept by the Supreme Court. So that came. But this is what it says on the Supreme Court's website under name change on the Illinois Supreme Court's role of attorneys and ARDC master role. So the ARDC does have a role, but it's separate and different than the Illinois Supreme Court's role of attorneys. And that's the one we want. The Illinois Supreme Court role of attorneys, the role is the list of all attorneys admitted to practice law in Illinois. The role includes the names of lawyers even if they are not registered in the Attorney Registration Disciplinary Commission, ARDC. The role is maintained by the Clerk of the Illinois Supreme Court. So the question is the title Clerk of the Illinois Supreme Court different than the Supreme Court Clerk? I would say that it is. You got a Supreme Court clerk, and you got a clerk of the Illinois Supreme Court. And so when you start looking at these things, sometimes you see it called the Supreme Court of the State of Illinois. Sometimes you see it as the Illinois Supreme Court. Sometimes you see it as Supreme Court of Illinois, without the state of. And so, which it's hide the peanut. Which one is the correct one? Well, they can tell me I want the role maintained by the clerk of the Illinois Supreme Court, whoever she is. Oh, and so what Roe did is she sent this blurb here, back to her. Said, well, this is what it says on your site. Please find out what's going on. And, well, they hadn't responded yet. A lawyer's name on the roll will reflect the name under which the lawyer was admitted to practice of law in Illinois or any subsequent change allowed by the court. And so all I can ever tell you is when you're going to be trying to explain this to somebody and they're going to say, well, they're an attorney, so you can't, because they don't want you to bring unauthorized practice of law against an attorney to the unauthorized practice of law people, because, that's an attorney. They are authorized to practice law. And of course, your complaint is that they didn't do it under the name on the roll. They did it with this initial, and that name isn't on the roll of attorneys. So this has to do with the very first split. Robert Allen Rytlewski became Robert A. Rytlewski as an attorney, if that's what the case was. They're not going to use their legal name when they go to court. And so they're not doing it as an attorney, because their legal name, basically, is going to be the one that's on the roll of attorneys. It's the one that's legally authorized to practice law, at least. Certificate of admission to the roll of attorneys licensed to practice law in Illinois and of good standing. To obtain a certificate of admission, good standing, from the Supreme Court of Illinois. See, now it's the Supreme Court of Illinois. What was it up here? Illinois Supreme Court. Right? I don't know what it is, so you're going to ask them for it anyways. Now, this isn't for you. This is for an attorney to get it. Send a written request, attorney's registration number, with your full name. Duh. Right? If you want to get a copy of your letter of good standing, you need to use your full name. Otherwise, we can't say, we'd have to tell you we don't have one for you. They can't get it unless they give them their full name. But they're using the name with an initial as an attorney with the registration number. And that isn't the name that can practice law. Admitted, yeah, I already read that. Maintained, yeah, the role is maintained by the clerk of the Illinois Supreme Court. So it's good to have had done this research and have it all set in front of you, because apparently when you talk to them, they're going to act like, well, no one's ever asked this about them before, so they're going to give some answer like the assistant clerk did. No, the list is kept with the ARDC. The Attorney Registration and Disciplinary Commission. Yeah, they have a master role, right? But they don't have the role of attorneys. The role is maintained by the clerk of the Illinois Supreme Court. End of discussion. Didn't say anything about the role of. It didn't say anything about ARDC. The role includes names of lawyers, even if they are not registered with the ARDC. So why would I call the ARDC? There's a chance they're not on there. No, I need the Illinois Supreme Court's roll of attorneys. I guess that would be the proper thing to ask for. There's the proper noun name. That's the proper noun name of the instrument we're trying to get our hands on. And so this section had all had to do with about name change stuff, and it got down to this: you must provide documentation evidencing your name change. So you could change the name that's on the roll of attorneys, but you need to give them evidence that you have changed your name. They're talking about marriage and things like that, but you could do a common law name change, and you can go to court and get a court certificate. Well, that's what you need to give them, the certificate that changed your name. And I bet you it changes on your Social Security, so now on your Social Security card there's a different, the names are going to match. Because the name on your Social Security card, really, that's your legal name. That is your legal name. Uppercase, It's your legal person. It's the name of your estate. It's your property. It's not you. It's your person. It's one of your properties. You are an immortal living soul, created in the image of God. Here is one of his people. You have persons. You're not a person. Right? You're not a human. You have a human. So, right, there's a thing I would call you got your natural person, your legal person. Your natural person is your proper persona person. That's the animal walking around with you inside of it. And your natural person, your artificial person, is your all capital letter name that was established for your benefit and is your trust account. And all that's ever happened is they're not letting you take your proper person name and attach it to the account that has the legal name on it. Right? There's an error in the record. And they don't want your proper person to ever show up, so they make your proper person disappear by giving you surname, comma, given name. And it has to do with being a U.S. citizen. I have to go find that form. But I was looking at just real quick, voter registration form. And it says you must be a U.S. citizen to vote. Okay, but it didn't ask you to check a box if you were. It asked you to check a box. Are you a citizen of the United States of America? Yes or no? Of course, most people are going to check yes. Well, the United States of America is not the United States. They're two different jurisdictions. So now you can't vote because you just said you're a you're a citizen of the United States of America, not a citizen of the United States. However, your legal person, uppercase name, is a citizen of the United States for, what do they call that? The jurisdiction issue they got to get past. Diversity of jurisdiction. Yep. They're going to go after that person, because that's a person. It's an artificial person, but it's a person. And you're its owner in your proper case, but they don't want that to be. They just want it to be like an account that's being administered by somebody else. And they're going to go try to tap your account. Rule 77. Now, this is in Arizona. Participants in unauthorized practice of law proceedings. Okay, so now we got something going on because somebody is going to complain about it. The complainant is not a party to an unauthorized practice of law proceeding. However, by becoming a complainant, a person submits himself or herself to the jurisdiction of the Supreme Court and the Superior Court for all purposes relating to these issues. So make sure that you are in your proper persona. A complainant shall maintain confidentiality of proceedings, if so directed by the Superior Court. The Superior Court shall send a copy of any answer or response filed by respondent, as well as any notice of final disposition of the matter to the complainant. And if they don't tell you you can't share it, you can share it with anybody you want to. The complainant may file a complaint on his or her own behalf in Superior Court, didn't say to go to the clerk, in Superior Court, if the state bar does not proceed with the case. So if we went back to this, where state bar, right, administrative side, if they're not going to do it, then you go to court to the judicial side. It's just that here we're looking at Arizona instead. All right, unauthorized practice of law counsel, that's what they call it in Arizona, the unauthorized practice of law counsel, shall have the following powers and duties: investigate all information coming to the attention of the state bar, which, if true, right, so you're going to give them an information, you're an informant. Normally when you try to give an information to the prosecutor at the county, they don't do anything with it. Right? So you're still giving these guys an information. It's not a sworn complaint, it's an information. They're supposed to investigate it. But what it just said is, well, if you give them a complaint and they don't investigate it, well, then you can go file one yourself in the Superior Court. And I just believe that this is where they're talking about you need to go into the Superior Court, the Circuit Court, the trial court of whatever jurisdiction you're in, right? The Court of Common Pleas in Pennsylvania, in the old courthouse of your county, probably on the top floor. Look for the one that says Circuit Court or Court of Common Pleas or whatever it is, and walk in there and say, I need to file a complaint. Chief Bar Counsel. For the purpose of investigation by unauthorized practice law counsel, the Chief Bar or the yada yada, the chair or vice chair of the committee shall have power to issue investigative subpoenas with the same force and effect in civil action in Superior Court. All right, this has got a tribunal on there. It's got the Chief Bar Counsel, the chair, or vice chair. Sounds like. So more about, doing this in court and not the idea is you don't take it to the clerk's office. You file it into the court. So, for instance, in Illinois, they have this thing about an office being declared vacant. If any county collector fails to count, pay the required amounts, the office may be declared vacant by the Circuit Court of the judicial circuit in which the county seat is located, in which the suit is brought on his or her official bond. Forgetting that and forgetting the bond, this is the important thing. If such suit is brought in the Circuit Court and based on preliminary evidence, the court determines it necessary that a temporary county collector be appointed, then the county board may, subject to consent of the court, appoint an interim collector. All that just to say, right, if such a suit is brought in the Circuit Court and based upon preliminary evidence. So you're going to take it to the Circuit Court. They're going to look at what you brought on your complaint to see if there's evidence, and that makes it and then they're probably going to swear you to the complaint, right? So now you got a sworn oath that went into the clerk, and they're going to give it to the prosecutor. There's three ways to get something into prosecution, right? One comes from an indictment, and that comes from the grand jury to the prosecutor. The other one's an information that comes from somebody outside to the prosecutor who decides if he's going to prosecute it, can prosecute it. And the third one is a sworn complaint, which is supposed to be something that goes before the proper magistrate first to see if there's evidence and sworn to, and then they're going to give it to the prosecutor. Well, they have us doing it as the information going to the prosecutor, and they don't want us to go to the court and give it to the court and have the court then give it to the prosecutor, because then the court would have said, yeah, we agree with them, and go investigate. All right, they want you to do the information. So this thing about doing an information into this counsel, if it doesn't do any good, the answer is to, according to this, to file a complaint in the Superior Court of this, if the state bar does not proceed with the case. What else do we have? And then there was a court case in Illinois. As an issue of first impression, the appellate court found that whatever this particular statute was, provided that a criminal prosecution for willfully failing to provide for the support of a spouse or child may be instituted and prosecuted only upon filing of a verified complaint by the person or persons receiving child or spousal support. Well, a verified complaint is a sworn complaint. Requires that a verified complaint be filed with the Circuit Court before criminal proceedings are instituted. Filed with the Circuit Court, not filed with the clerk or the Circuit Court clerk or clerk of anything. File with the Circuit Court. The court rejected the state's argument that some section is satisfied by filing a verified complaint with the state's attorney's office. The court said, no, you need to file it with the Circuit Court, because filing it with the state's attorney's office is no more than giving them an information. That's very interesting. I mean, that's huge, right? You need to understand. You go to the trial court with your complaint, and we just figure out, hey, Judge, I got a question about filing a criminal complaint into the court. I believe I'm supposed to be here to do this. I don't want to do it as an information, and I can't get it to the Supreme or to the. Well, I don't want to do it to the grand jury. I want to file a complaint and just see what they say. But the place to do it is in the court that says above the door it's the proper jurisdiction. The court rejected the state's argument. Something infers the state's attorney's exclusive discretion to initiate and manage criminal proceedings, right? The court said, no, you don't have the exclusive discretion to initiate a criminal prosecution. Huge. Although the filing of a verified complaint with the trial court is a necessary prerequisite for the state's attorney to file a charging instrument, once a verified complaint has been filed, the state's attorney retains discretion concerning whether and how to prosecute the case. But they can't stop the fact that a verified complaint can be given to the trial court, and they're going to give it to the state's attorney to initiate a criminal proceeding. Right? Before a criminal proceedings are instituted, you have to file a complaint with the circuit court. Now that's what the state's attorney is going to do, to the ones they want to. They'll go file a complaint with the circuit court. Or, have the one you have filed with them. I'm guessing. Or they're not doing any of that because they're not following any law, so I'm not going to even give them that benefit. They're not doing that. But we're supposed to do this. Now, Roe had found because she found a court schedule, and the courtroom is on the 4th floor, and it says above the door, Circuit Court, but when you look at the assignment of courtrooms and judges, that courtroom says vacant. I can understand why that would be, because the person we think is the chief judge of the circuit court for the county is using her middle initial on her oath. And she didn't use her middle initial as an attorney. And to be a judge in Illinois, you have to be an attorney licensed to practice law. And that's with the full middle name. So they can't use her middle initial. But they are. So I don't know if any of this do any good because of all those things, and that's why, we'll take it all the way to the United Nations human rights violation, because they're not following any of these laws that say this is what they're supposed to do, or they're hiding it from us. But it's real easy to see that they're not allowing my proper persona to be seen in public. It's always surname, comma, first name. Right? Because no verified complaint was ever filed with the trial court, it was improper for the state's attorney to initiate a criminal prosecution. So if you're going to court for any kind of criminal prosecution, according to this, the complaint had to have been filed with the circuit court, not with the state's attorney's office. Any criminal prosecution, to initiate a criminal prosecution, it's improper for the complaint to have come through the state's attorney's office. It has to have been filed with the trial court. Because no verified complaint was ever filed with the trial court. Can't get past that. It was improper for the state's attorney to initiate criminal prosecution. No verified complaint was ever filed with the trial court. Good stuff. Work on that. Okay, now this is Arizona, Rule 74. And this had to do with certificates of good standing. So you find this in every state. These are like Supreme Court rules. Right? So you've attorney certificate of good standing. Court rules for certificates of good standing. You just Google things like that. To request a certificate of good standing, please read the entire page. Make sure that you do. And send it to Supreme Court of Arizona, Certificate and Licensing Division, yada, yada, yada. So Right? So they talk about this certificate. Normally, all requests for certificates of good standing processed within 5 full working days of receipt. But please allow additional time for processing a highest court request. Well, I thought that's who you were sending it to. This is the Supreme Court of Arizona, and I'm asking for a certificate of good standing. So what are they telling me? Are they telling me there's a higher court than the Supreme Court of Arizona? Please allow an additional time for processing a highest court request. Okay, so please note, in some jurisdictions require a certificate of good standing from the highest court of the state. We do not have information on which jurisdictions do or do not require a highest court certificate. And you should verify with that jurisdiction the type of certificate you need. So obviously there's more than one kind before submitting your request. These could also be referred to as certificates from the Supreme Court or from the clerk of the Supreme Court in various jurisdiction applications. If you require a highest court certificate, please clearly state this on your written request. This will ensure that you receive a certificate from the disciplinary court as well as a certificate from the clerk of the Arizona Supreme Court. If your initial, first or middle, appears on the state bar membership database, your full name will appear on the certificate of good standing. Now, it's interesting because in Arizona, there's no requirement to be a member of the bar. In Michigan, there is. And so maybe they can use their middle initial. But in Michigan, it says that the bar gets a copy of the certified list from the clerk. And when you look at the names on the state bar site for Michigan, for attorneys, they almost all have their proper name, middle name in there. And you may look at some and say, well, that looks right, especially for a lady. But then you go and you find some court case, if you're lucky enough, that she's been involved in, and you find, oh, she's using 2 last names when she signs things. But on her license, she just has the one name. The public can also request a disciplinary history on a member of the State Bar of Arizona. These histories only include formal matters which are public information as required by Rule 70. Okay. Well, of course, if because you got to do it in their full name, and the full name's not going to ever have anything against it because no one's ever tapped on the full name. So, but it's the full, this is, whatever name is on the certificate is the name that could practice law. Okay. So this is Rule 74 of Arizona also. Certificate is issued by the Supreme Court. In those instances where the certificate of a good standing must be issued by the court, the certificate shall be presented by the disciplinary clerk. I don't know who that is yet. Who's the disciplinary clerk? To the clerk of the court. Of what court? What clerk? For signature based on disciplinary clerk's written recommendation that a certificate should be issued. So this disciplinary clerk, that's interesting. Except that I provided all certificates related to good standing or lack thereof of members of the state bar shall be issued by the disciplinary clerk for and on behalf of the court. Unless, right, needs to be, the one from the highest court. The certificate shall be presented by the disciplinary clerk to the clerk of the court based on the disciplinary clerk's written recommendation that a certificate should be issued. So it's going to be authenticated, right? That's what they're going to do. They're going to authenticate the disciplinary court's decision. That make it a public record. The disciplinary clerk shall collect all fees, right? So there could be more fees. The form, okay. The form of the certificate shall be as follows. Certificate of good standing issued by disciplinary clerk for and on behalf of the Supreme Court of Arizona. Certifies that according to the record. State bar was duly admitted to practice. Okay, just gives you an idea what it's on there. But so, as we're going to see here in a minute, there's forms to use to do the administrative side to these committees they set up. But as it said, you can always go to the court yourself and put in your own complaint. And it looks like to do the complaint, you got to go to the court, open court, trial court, whatever it is, and have a verified complaint go through them to be prosecuted. And it would be prosecuted for the unauthorized practice of law. All right, so this explains what that is, but the main thing is a person who violates this section is guilty of contempt of the Supreme Court and of the Circuit Court of the county in which the violation occurred. Upon such conviction is punishable as provided by law. It's direct criminal contempt of court to be engaged in the unauthorized practice of law. So you should really only need to walk in with a piece of paper with that frickin' attorney's name where he signed some court form, using the middle initial or whatever, and say this person's engaged in the unauthorized practice of law. That's not an attorney. I don't care that he has another name that's correct. No, this name is not. This name, Your Honor, this name is not on the roll of attorneys. Your Honor, this name is not on the roll of attorneys. Your Honor, this name is not on the roll of attorneys. That's a violation of the Supreme Court. They're in direct criminal contempt of the Supreme Court. And if you don't do something about it, Judge, so are you. Right now, they can say whatever they want, but that is what it says. And until it's been tried, you can't say it's not going to work. Okay, give me just a second here. I got to jockey some stuff. Okay, so in Michigan, if you were going to go the administrative route, for most things to do with attorneys, they want you to send it to this Attorney Grievance Commission. In fact, I filled one of these out not too long ago for a brother here in Michigan, and we may have to go back and send one now to this other place. But, basically, it's going to go to the Attorney Grievance Commission, Griswold Suite, 1700, Detroit, Michigan. There's that one. But they have another one for the unauthorized practice of law. Right, that's going to go to State Bar of Michigan Authorized Practice Law Department in Townsend Street, Lansing. Now, was that different than the other one? I believe that it was. Yeah, Griswold Street. Right, so these are two different agencies completely, obviously. And it's just a very short thing, right? Non-lawyer's name. So here you would put the name with the middle initial, however you find it written on the frickin' paperwork they gave you. Address, city, state, zip, telephone number. I don't know if you're going to have that or not. Whatever you have, you're going to use, right? If you can get a business card from them, you're in excellent. If it's the prosecutor, well, then just use the address of the county building he's in. Describe your complaint. Because, again, if you look at a prosecutor's name, they're not going to be using the name that's on the roll of attorneys. And neither is the assistant prosecutor. And neither is the assistant deputy attorney or the assistant district attorney. And neither is the frickin' U.S. attorney. None of these people are using the name that they have on their license. And none of the judges are using the name that's on their license. So that name they're using was never an attorney. So that name they're using could never have been a judge. So anything they've ever done has to be overturned because they didn't do it as a judge. Right? They did it as a form of an antitrust scheme. Tax evasion, antitrust, things like that. Describe your complaint. I got some court papers. See Exhibit A. Has this guy's name on it. Whatever it is. I don't find him on the roll of attorneys. or I don't find him on that name listed as an attorney authorized to practice law within the state, please investigate. That's all you really need to tell them. Don't need to point out a bunch of laws. All right, this is the administrative side. Now, this ain't going to go to court. This is going to go to a group that's going to look at it and see if there's probable cause to send it to court. And if they won't do that, well, then you have the other option, which is to take it to court yourself and get a verified complaint through the trial court. But don't take it to the clerk. Take it to the trial court. And if it's for a federal one, you don't take it to the federal trial court. You take it to the state trial court, because even the attorneys that work, that are working in the federal building and so forth, they have to be members of the state bar to practice law within the state. So this is one way to do it, right? And we're going to be pushing on this here. It's the holiday, so it makes it a little bit harder, but we'll see how that goes. And so there are obviously two different places, and the one you want is you want to look up the unauthorized practice of law and follow it. But there is another way to do it, right? And that's through the human rights, United Nations Human Rights. And they have a complaint procedure. And let's see what that says. 2007, adopted a resolution entitled, whatever it was, addresses consistent patterns of gross, reliably attested violations of all human rights and all fundamental freedoms occurring in any part of the world and under any circumstances. Okay. Are they going to do anything about it? Well, hell, I don't know. But they said I can complain to them, so I will. And I did, and I'm going to read that here in just a second. But that was the whole reason, because they say that you can. Right? The complaint procedure addresses communications submitted by individuals, groups, non-governmental organizations that claim to be victims of human rights violations or that have direct, reliable knowledge of such violations. So I had tried before to take and put a complaint just into the International Criminal Court, because it says you can. And sent it to the prosecutor and never heard a word about it. Well, that's the same as you taking an information to your prosecutor at the county. That's that way. Well, another way is to do it more like through a grand jury or a court that's taking a complaint to look for probable cause, and that's what this is. These guys are like a court looking at it for probable cause before they send it on to whoever it needs to be sent on to. But they're going to investigate. How does it work? Let's see, how does it work? Due to strict working groups are responsible, respectively, for examining written communications and bringing consistent patterns of gross and reliably attested violations of human rights to the attention of the council. Yeah, we didn't need to use them. We're just doing it ourselves. So when you get down to it, eventually they tell you how to submit communications. Please fill out the complaint procedure form if you consider communication meets the above criteria. And this is what that form looked like. And as I looked at it, and I got this first one, and then wanted my last name first, I said, well, I can't use this form. I'm going to have to, I'm going to use my own form. So that's what I did. So while they have a form for you to use, I don't want to put my last name first. That's not my proper persona. And so I pointed out to them that I didn't believe them asking me to do that was proper. But so it's easier for me. Sometimes just to read what I did and try to explain it as I go through. So bear with me. So anyway, so following what they wanted me to do, right? I found this address on the form, and that's where I ended up sending it to. Now I do see they have an Office of Human Rights in New York also. I haven't gotten that far because I just did this a couple days ago. And so I did it this way, complainant individuals, right? Myself in my stuff in Rosita and hers, because I'm complaining about one thing and using Ro's case as the evidence for the thing I'm complaining about. So it'll make more sense in a second. So asking me to be Rytlewski Robert Allen, which is basically what they did by this form here, is enforcing the disappearance of my proper persona, and it seems improper for the United Nations to violate its own laws by asking on its complaint form for me to identify myself in that manner. I consider it slander of my God-given character. Rytlewski Robert Allen is a fiction created to confuse the rights of ownership in the legal name entity, Robert Allen Rytlewski, all caps. For the record, all caps is the natural person's personal property. The name of my estate and its assets are unlawfully withheld from me. I believe there is a mistake at Social Security in the master file. Rytlewski Robert Allen and Robert A. Rytlewski is not, or Robert A. Rytlewski is not my proper persona. This complaint is in the names of two natural persons in proper persona, representative of man within the United States, who find themselves in a civil disability caused by a clerical error or intentional omission. There's something wrong in your Social Security record, and that record goes to all the other agencies and provides them your information. This inferior civil status makes us prey for private law manipulators wishing to administer our estate, your all caps, and its accounts, or by identity theft, transferring our wealth to others' use. Either they want to administer it or they just want to be us. Right? That's what you do when you hire an attorney and give him power of attorney. You gave him power over your estate. And he's going to transfer his use to someplace else by stealing your frickin' identity. Because he's not doing it as an attorney, although he said he was. It has been said that the United Nations is aware that most of the population of the United States is considered as alien by that entity. And that was from Rod Klass's brother, who talked to people at the United Nations, who said that either we're resident aliens or some kind of alien status. You're not a U.S. citizen. It is a resultant inferior status a clerical error or presumed voluntary decision not to establish domicile in their jurisdiction? Or is it part of a scheme by organized criminal syndicates to enslave mankind? How can it be corrected? Whatever the reason, its effect is the enforced disappearance of person, proper persona, in violation of Rome Statute Article 7, Crimes Against Humanity. And if you go look at, just Google Rome Statute, you'll find it. Look at Article 7, Crime Against Humanity, and they have one in there about the enforced disappearance of a person. And that's what we're talking about. They won't let your proper person be seen so that somebody else can administer your legal person. And they're going to keep you a John Doe by giving you a legal fiction and say, well, that's who you are. You're homeless. We asked, complainants have two requests. We asked the United Nations to immediately initiate equitable relief for Rosita in case number, that's the case she's involved in, and any other incorporated by reference, filed with the clerk of the Circuit Court, Kane County, Illinois, and her persecution of the matter. We further ask that our proper person status be recognized, and that control of our legal person and its accounts be transferred to its rightful proprietor for our use and enjoyment. And we are its rightful proprietor. I should have said us, its rightful proprietor. And acknowledgement of full rights of citizenship executed. Right? Make me a citizen. Tell me how I need to do it. Make them tell us how to do it. I am not exactly sure how to address the state involved, as it is known to me by many names. America, United States of America, the Union, U.S. are examples. But the originating crimes happen in the member states, subject of international law, in this case, Illinois and Michigan. Because all the federal government does is sign for everybody else, but they're all, by reference, they're all subject of international law, which is why they were able to take the governor of Arizona to court in the United Nations for their law that had to do with illegal aliens. We're talking about aliens, jeepers. I am not exactly sure. Okay, I said that. The state is either unable or unwilling to intervene in a simulated legal process, the court case, conducted under color of law in violation of every Civil Rights Act since the Civil Rights Act of 1866, Section 2. The result is the enforced disappearance of our proper person. Torture, enslavement, human trafficking, disenfranchising, to name a few. The situation is caused by members of an organized criminal syndicate, those authorized to practice law in the state, participating in supposed legal proceedings outside of their official capacity, creating unapproved court forms, omitted information, signing in a name other than the name they certified with the highest court of their state. The name found on the roll of attorney certified by the clerk of the state's Supreme Court is not the name attorneys and judges use on supposed court documents. They are not in their official capacity. They are usurping the powers of an office as enemies of the state. By blatant disregard for oath of office, they subscribed rules of conduct they consented to, should have been double O, to abide by, maybe not. And in criminal contempt of court, they have involved themselves in antitrust activity, tax evasion, and human trafficking, enslavement in every court in every city or county of every state. They are aided by judges selected from their ranks of attorneys authorized to practice law in the state and bound by these same rules and judicial canons. These judges do not have a valid oath of office. They do not sign court documents in the name found on the roll of attorneys. These actors involved use aliases, omit court seals, counterfeit notary acts, mislead, bear false witness, and all the while pretending to be public officers and leaders of society. Their antitrust activity results in the confiscation of private property, tax evasion, human trafficking, murder, treason, and denial of the Holy Ghost. Written procedures replaced by unwritten custom, allowing errors and omissions in official records. They just don't follow the frickin' written law. They do it by custom. I tell you, it's just the way we do it. Form prevails over substance, allowing fictitious plaintiffs to bring suit under a fraudulent process orchestrated by attorneys in violation of their bar membership agreement, its code of conduct, and their oath of public office. Unauthorized forms signed by de facto public officers using some name other than their proper persona are filed as legal documents. These instruments have no lawful authority, yet are enforced by private police impersonating peace officers. Facts in support. Rosita has been enslaved by the enforced disappearance of her proper persona in violation of the American Declaration of Rights and Duties of Man, Universal Declaration of Human Rights, and the Rome Statute of the International Criminal Court. Other violations of the same declarations will become self-evident upon examination of the facts and documentary evidence. Oh, I need to go get that documentary evidence. Give me just a second here. Okay. So where were we? Okay, Rosita, a member of the Latin Church and subject to the laws of that society, was accused by usurpers of civil office of having committed a breach of peace resulting in an alleged complaint filed for disorderly conduct on the 7th of August 2013, initiated by a police report as noted on Gen number, see Exhibit A. Sandy Wegman, the supposed complainant, claims to be the Kane County Recorder. Kane County is a private association, not the government of the County of Kane. Kane County officers and employees have usurped the powers of state within the County of Kane. Right? Kane County is not the same as County of Kane. Exhibit A was only provided to Rosita some months after the incident when she complained that during her hearing that there were no charging instruments in the simulated legal process, the supposed hearing, under the court case, filed with the clerk of the Circuit Court, Kane County, Illinois. Exhibit A contains a simulated uniform citation and complaint form and is not the form approved by the Conference of Chief Judges and filed with the Supreme Court of Illinois as required by Illinois Supreme Court Rule 522. And all that is saying is that this thing here to the left is supposed to be the Uniform Traffic Citation Form. And in Michigan, they actually have a court form where this is blank over here on the left. All this other verbiage is kind of on there, and they're supposed to, staple the frickin', because it's really like a card that goes here. Right? It's not a full-size sheet of paper. This box, the size you see it, is the size, or should be the size, although this is probably smaller than the proper size, of what this document is supposed to be. And so, if this was the true universal ticket and citation form, it should be filed with the Supreme Court. But as I showed in the earlier videos, I'm not going to go find it. That isn't what it is. This isn't the one that is filed with the court, or that was approved by this commission they're talking about. The Conference of Chief Circuit Judges. If it was, right down here on the bottom, it would say that it was approved by the Conference of Chief Circuit Judges, and it doesn't say it. Yeah, I can get it, maybe. Maybe it's right here. It's just good to look at. All right, Conference of the Chief Circuit Judges have said, here's the form you're going to use. And this is what it looks like. And if you were to look at this closely enough, you would see that, this isn't the same as the one they used against Roe. So, they're not using the right form. Therefore, the use of Exhibit A is direct criminal contempt of the Illinois Supreme Court. It also evidences an act of notary misconduct, as the certificate is not in conformance with the Illinois Notary Act and includes various omissions. Exhibit A indicates that the defendant did not need to appear for any judicial proceedings. All right, they crossed all this shit out about coming to court. This is supposed to be the charging instrument. They're going to charge Roe disorderly conduct, which in the city next to this is a $35 fine that they have her up to a $3,000 bond down now, and want to give her a inpatient or outpatient treatment for a condition, but it's been checked off as a physical condition, not a mental condition. And that's what's keeping her from being able to appear in court, is her physical condition. Yeah, she's a decedent. She hasn't appeared. They didn't check it. I mean, it's profounding the crap that they've done. It does make you chuckle once in a while. Okay. Not only is the form fraudulent, but also the person that filled out the information committed a crime against humanity by filling it in as, her last name, first name. That's what they did. They filled it out. They had her state ID, which has her name Rosita first, first, last. It's Rosita Staskovine, not Staskovine, comma, Rosita. Whoever filled this out began the process of the enforced disappearance of her proper person. And it only gets better. Step 1. Okay. Where are we at here? The same day that this was going on, because she got this later. Oh, and in fact, it only goes farther than that. They did that. But they're using the zip code doesn't go to the mailing address. It's the wrong zip code for the street address. So if they're going to try to send any mail, it's never going to get to that place. They got the wrong zip code on it. The same day, Rosita was unlawfully arrested and taken against her will to a private facility as part of the antitrust process used to coerce the assumed consent of the victim by requiring a signature on a false bail bond form, see Exhibit B. From local court rules, bail, that's F, bond court, bond hearings in all traffic misdemeanor and felony cases in which the bond has not been set previously shall be conducted in the bond court. So I don't know if it's ever been set. It has been set at $120 by the Supreme Court, but it's not the way they mark the paperwork. That would be Exhibit B. So here's where they got Roe. See, because who's the defendant? There's Stascavine Rosita. And who do they get to sign as the defendant? Rosita did. And Rosita said when she went to court, this is the piece of paper that the judge is holding up for people and pointing at where it says signature or defendant and saying, is this your signature? That's all she cared about. Is that your signature? Once you sign there, are you saying you are Stascavine Rosita? You're not Rosita. You're not Rosita. Stascavine. Sorry, Ro. And you can see they didn't charge her any dollar amounts. They put 120 with a mark behind it. 120 and 1200, right? Bail set at 12. What's that? 12 o'clock. It was set at. Set for noon. So is that when her bail hearing was supposed to be? And this form doesn't. This form is also not correct because they have one that is correct. So there was no hearing, but she was told she would not go home until she signed it. Exhibit B is the only instrument given to Rosita this day. After signing it, she was escorted to a side door of the building, led outside, and left on her own to find her own transportation home. Right? Don't let us catch you driving now. Allegedly, Exhibit B is allegedly setting bail at $1,200. What? It indicates Rosita provided a 10% bond for the defendant, known as who? She is coerced into enslavement by providing her signature identifying herself as the defendant, whomever. The defendant is not the proper persona for Rosita. Prosecution as the defendant, Stascavine Rosita, causes the enforced disappearance of her person, Rosita Stascavine, in violation of Roman Statute Article 7, Crimes Against Humanity, and allows for ease in human trafficking. Exhibit B is not in compliance with the Illinois General Assembly, which defined the requirements, which said the written notice on this form, there has to be a written notice, distinguishable from surrounding text in bold, typed, or underscored, and a size 2 points larger than the surrounding text. All right, that's B. All right, and I'm afraid there's none of that on here. So this form is in contempt of the General Assembly of Illinois. Okay. Some months later, we're trying to locate the jurisdiction for defending against color law simulated legal process. Rosita was again falsely arrested, falsely imprisoned by co-conspirators in the crime against humanity were claiming to execute an arrest warrant. Doesn't matter how many times I read this, I still make mistakes. I'm the worst speller in the world. You have to forgive me. Sorry, UN. Put up with it. Let's look at the arrest warrant. Let's look at the stuff that matters, right? Now, this is supposed to be an arrest warrant. But it's never been returned. There's no return of service. This served down here don't mean squat because it ain't in the box. It ain't in the form. It's outside of the form. I have executed this warrant by arresting the within named defendant on the day and time indicated below. Not a thing in there. This form was not done right. And what's the signature of the judge? Flood Betsy. Right, so this is one of the things we pointed out in one of the many complaints that we sent to like the Attorney Grievance Commission for Illinois, and they wrote back, said they didn't think that was a big deal. We don't see there's anything wrong with on an official document using the name Flood Betsy. All right, so we appealed that, and we're saying, well, in that case, we're going to go to up the chain and send it to the Judicial Committee, because she's, doing this as a judge, and we had sent it to the Attorney Grievance Commission. Again, because Elizabeth K. Flood, as we'll see, isn't on the roll of attorneys, and if she wasn't on the roll of attorneys, she never could have been a judge. So she never was a judge, and anything she's ever done trying to be a judge is just usurping the powers of a judge, and you're going to have to undo it all, and if she continues on, well, now you're just warring with the Constitution, and that could be construed as treason. Reading the verbiage, the defendant was taken to the nearest magistrate. Okay, that's what it says on there, right? So that's the other thing. The arrest warrant, it says up here, you're hereby commanded to arrest the defendant designated herein and bring said person without unnecessary delay before a judge of the Circuit Court for the 16th Judicial Circuit, Kane County, Illinois. Well, none of that ever happened. Right? They didn't. They were commanded, and they didn't do it. They didn't follow a command. And also it uses a zip code of 0000. It's got the +4 on there. That's good to look at. These are just things you look for, right? Because here's the defendant. Who's the defendant? Right? This is just a form of a Jane Doe. That person doesn't exist. You didn't show up in proper persona, so you're not the defendant. They don't really have a name for the defendant. But here's the zip, 0000. I'm going to have to try this one time and have somebody address something to me, but put the +4, 0000, so it shows up, and see if it doesn't show up then. Right? Because I found other paperwork where when they put the +4, 0000, it was a courthouse. And if that's what the machine is reading as a zip code, well, there you go. It's going to go directly to the courthouse. Doesn't matter what the street address is or nothing else. You just go to the courthouse. Okay. Anyways, now's the time to note only sworn peace officer is authorized to arrest someone, and Exhibit C gives no indication of the involvement of a public officer. These actors are not peace officers. They are rent-a-cops. Right, so they arrested her and they made her sign another bail bond form for $3,000 now instead of $1,200. It's another simulated bail bond form. It's not the correct form, right? It's direct criminal contempt of the Supreme Court. After numerous hearings in which Rosita is not allowed to participate except through her assigned public defender, the prosecution continues. The prosecutor has no intention of ever bringing Rosita to trial for disorderly conduct and instead attacked her credibility and mental state. Rosita was threatened with incarceration for civil contempt as she did not attend a mental evaluation. Like so many other facets of this violation of human rights, the mental evaluation was conducted by a presumed clinical psychologist, because we never did see their license, but it wasn't done in their official capacity. It says so right in the frickin' paperwork. When a clinical psychologist does this evaluation for the church, basically, for the court, they're not doing it in their official capacity. Right? So you could have had anybody do the evaluation because they're not doing it in their official capacity. Eventually it led to an order from the belligerents that Rosita needed outpatient treatment, but the order is written for someone with a physical disability, not a mental disability. Right in the order. Section whatever it is, and you go read that section, because there is a section for mental disability in there, and that isn't the one they quoted. They quoted the one for physical disability. The Illinois Department of Human Services is now involved as the agency to oversee Rosita's treatment. However, by its own rules, the department requires a court order certified by the clerk of the court. Just got to read their rules, and by God, there it says it. and Rosita's assigned evaluator has confirmed that the order he has is not certified by the clerk of the court. I mean, this Department of Human Services, they wrote the frickin' statute that says it has to be. Well, they didn't write the statute, but they helped put the statute together. That has to be. And I showed a book where they're showing how all this stuff goes together. And they're not doing it. Right? Rosita has filed complaints to various agencies in an attempt to find relief, such as the Kane County Sheriff's Office Internal Affairs, Kane County Sheriff Office Police, Kane County State's Attorney, Kane County Ad Hoc Committee, Illinois Executive Office of Inspector General, Department of Human Services Inspector General, Attorney Review and Disciplinary Committee, Judicial Inquiry Board, Illinois Secretary of State Police, Chief Judge of the 16th Judicial Circuit, as well as numerous motions and petitions into the case. What has been uncovered during her ordeal and now presented to the United Nations is that the practice of law, which is governed by the Illinois Supreme Court and its rules and procedures, is being violated with wanton abandon by those who have sworn to God to police said practice. Attorneys are not signing legal documents in their official capacity. They do not use the name they certify with the clerk of the Supreme Court and kept on the role of attorneys. Instead, they use a fictitious name, omit information, use unauthorized forms, all in violation of their code of conduct and direct view of the supposed judge. Indirect view of the supposed judge. These judges have not filed a valid oath of office. Instead, they file a counterfeit one. See Exhibit D. Here you go. This is what Elizabeth K. Flood filed. This is supposed to be her oath of office. Again, there is no Elizabeth K. Flood who was ever a licensed to practice law, so she could never be a frickin' judge. So this is fictitious. And then the undersigned, being duly authorized to administer oaths, certifies a foregoing oath of office administered on some day, right? Signing as the chief judge, but there's no seal on here. Right? They're doing this as a notary act, the act of a notary, and an act of a notary in Illinois has got certain things need to be done, and none of it has been done, such as to determine the jurisdiction of this piece of paper. Should say in the state of Illinois, county of Kane, or wherever the hell they're at when they're doing this, and it doesn't. And so it looks like Judith M. Brokaw is the chief judge of the seal of the Supreme Court, and she isn't. She's just the chief judge of a judicial branch of the circuit court, and she isn't that. Because Judith M. Brokaw was never a frickin' attorney. So she never could have been a judge. So she could never have signed here as the chief judge. Which makes this oath invalid. Yeah. Crazy. These deceivers are aided by co-conspirators acting as executive branch officers, both elected and appointed, who have not filed proper oath, official bond, or simply usurp the powers of a vacated office. Usurpers of law enforcement powers initiate a controversy to coerce a signature on an instrument claiming indebtedness to some monetary amount to an improperly organized municipal corporation. Many of the agencies involved claim to be tax-exempt government units. However, they cannot produce the documents required by the Internal Revenue nor State Revenue Office to substantiate this claim. These entities have no lawful authority to represent the government and are instead involved in antitrust activity, tax evasion, human trafficking. It has come to our attention that the United Nations is cognizant of the fact that people like Rosita and myself are considered aliens. I was born and raised here on this landmass called the United States. If I am considered an alien of this is known to the United Nations, then where is it I am a citizen of? What is the process, and who do we contact to cure our civil disability? If the United Nations cannot determine my citizenship, then I ask them to provide me a stateless status and documentation, such as a UN passport instead of a U.S. passport. Personally, I think I am a citizen of the Vatican City State, more properly the Holy See. I have a baptismal certificate for my proper persona and ask for recognition of my status as a Holy See citizen. Please consult the Secretary of State of the Vatican City State. See if they'll do it for me. Americans do not need to look any further than their mailbox to find evidence of enforced disappearance of persons, simulated legal process, color of law, civil disability, and the like. It is here, it is close, and it is evil. We look to the United Nations to fulfill its mandate and execute international law on our behalf. See that our proper person is internationally recognized as a citizen and the acknowledged owner of our legal person and its account. In the name of Jesus Christ of Nazareth, the holy name of Jesus, do your duty. And I sent that out on the 22nd. So, again, I sent this to the UN over in Switzerland by email. I haven't tried to do anything yet with New York, but I will. So here's the thing on this form, right? What they're really doing with this form. I understand, I, the undersigned defendant, do hereby acknowledge myself to be indebted to the people of Illinois or the city or village set forth as a municipal corporation in the sum indicated as bail. Right? You're indebted to the people of Illinois. The people of Illinois is not the government. All right? Because again, if you were to go look at what you would do if you were going to sue in the court of claims, the defendant would be the state of Illinois, not the people of Illinois. Well, if this is a criminal matter and I broke a law that has to do with the state of Illinois, then they're the ones that should be bringing the claim. And they're not. It's the people of Illinois. And all they're doing is saying, hey, you owe us $1,200. You signed right here and said you owe us money. Right? This is all about a meritorious claim. A claim about making money. Use an antitrust methods, if you could call it that. Okay, I got one more to read, and then I'm going to call it a day, but I do want to read this because I did do it, so I don't want to put it on public record. Hang on just a second. Okay, I'm not going to have time to do both of them. I'm just going to do one. So earlier this week, before I did anything to the United Nations, I had sent one to the Jesuits, bitching to them about stuff, pointing out the same thing. Hey, because the same shit happens in the church as happens in society, and I pointed that out in other videos, so I'm going to take it to as it turns out, the Jesuits have a Jesuit curia in Rome, and they're, the Pope's a Jesuit. I'm going to get it to him. Let him deal with it. Because he will. In fact, he just came out and he's really going to spank the curia. He's already shown that he will send one of their own to prison when he took an archbishop from Dominican Republic, and the Vatican City State is prosecuting him right now. And he just called them all out here yesterday. 15 ailments of the curia. And he's not very happy with them. So I said, okay, I'm going to find some Catholic attorneys and send... Again, the main problem is what's happening here in America. Let's take care of that first. As much as I like to get all my property and get my proper persona and so forth and so on, maybe what needs to be done first is we just need to stop what's going on in a particular court case so they leave you alone. How are we going to do that? So I'm going to send a mass email to this Catholic Lawyers Guild of Chicago. And when you look through it on here, they got... where was the one? Here we go. First of all, notice they're all advertising on here as attorneys because they're on their site, and this is a membership site of lawyers, and they're not using their proper name. surname, comma, first name. It's not the proper name. You can't advertise as an attorney with that name as far as I'm concerned. And this dude is a U.S. Court of Appeals 7th Circuit judge, I guess. And so if you want to get a hold of somebody in the 7th Circuit, it looks like the way you do it, if you're trying to figure out what their email addresses are, chambers, lowercase of, lowercase judge, over lowercase, with their name. And then this is ca7.uscourts.gov. Now, it must be Circuit 7. So whatever circuit you would have, right? Because this is the 7th Circuit Court of Appeals. Oh, Court of Appeals 7. There you go. .us.gov. And that's good. And then I found a guy in here that's on the, where did I just, oh, here we go, Illinois Human Rights Commission. Well, he's getting a copy too. And so I just copied and pasted all these guys' email addresses, and I wrote a little complaint that I'm about to send today. But I'm going to read it now and get it on the record. So, in the holy name of Jesus, I pray you read, and I'm talking about all them frickin' attorneys. Catholic attorneys advertise in your surname given, as seen on the Catholic Lawyers Guild of Chicago website, where I found your email address, could be construed as the unauthorized practice of law under a fictitious name, because it says a lawyer's name on the roll will reflect the name under which the lawyer was admitted to practice law in Illinois, or any subsequent name change allowed by the court. And there's the link, because I'm going to put this in email. They can go link it, read it themselves. I will explain in more detail, but first I must ask that you help a local Catholic sister who finds herself the victim of a human rights violation. It seems Kane County practices color a law and simulated legal process as part of an antitrust scheme, evading taxes and usurping the sovereign powers of the state. Kane County is not the government. Kane County is a for-profit company, hiding as an assumed non-profit corporation. I say assumed non-profit because Kane County does not have a determination letter from the Internal Revenue Service acknowledging their nonprofit status. You're not nonprofit till the IRS says you're nonprofit, and they'll give you a piece of paper for evidence. And if you ain't got it, well then you're not nonprofit. And when they give you a W-9 and you look at it, and there's supposed to be a signature of the person, there should be a seal of the government on there, because that's who the nonprofit organization is, not some person's name. Didn't ask for that. It's the name of the person for the W-9 that's supposed to put their signature there. And the signature of a corporation is their seal. Anyways, her persecution is possible because individuals listed on the roll of attorneys, bound by oath, officers of the court, engaged in illicit acts of enforced disappearance of person, numerous other crimes against humanity, and grave sin of denial of the Holy Ghost. You need to know that using any name as an attorney at law, other than the full name found on your certificate of good standing, could be construed as the unauthorized practice of law, professional misconduct, false impersonation of public officer, certainly probable cause for an investigation into such matters. And so that's what we're going to do. We're going to start taking their names off these lists and just keep putting them in one at a time. And they won't know the hour is coming. That's what will happen. So to obtain a certificate of admission in good standing from the Illinois Supreme Court, send a written request for your full name. All right? Because again, you need to use your full name, other than the full name. You need to know any form submitted into court or clerk, other than those authorized by the Conference of the Chief Circuit Judges, could be direct criminal contempt by law enforcement, its prosecutors, and the judicial officers involved of the Circuit Court of Illinois. You need to know that you are an oath-bound public officer who, in that official capacity, has a duty to report misconduct of other attorneys authorized to practice law, reporting unauthorized practice of law, to please your membership and to ensure they are acting in their official capacity, using the name found on the roll of attorneys, using authorized court forms, and prosecuting as criminal contempt of court the use of non-authorized forms. You need to know, we, the citizens of the kingdom of heaven here on earth, hold you to your promise to our Father, maker of heaven and earth. You need to know that the occupant of any judgeship that requires the occupant to be an attorney authorized to practice law who is using a name different than found on their certificate of good standing has usurped the powers of a vacated office, is warring with the Constitution, and you are committing a misprision of treason by not reporting him or her. I'm afraid that's the way it is there, 7th Court of Appeals judge. You need to know you are warring with the Constitution if you're not using your full name on your license. You need to know that the propria persona is certified on a certificate of baptism, indicating the Universal Church and its courts have in personam jurisdiction over that individual, and you violate their civil rights by coercing them into an inferior jurisdiction. If you look at a certificate of baptism, that's the only document I have found that has your frickin' proper person just the way it should be. Upper lower case Robert Allen Ritlewski. And then on any state forms I can find, the one I can find it on is that certificate of baptism from the Universal Church, which has its own courts, and that means they have in personam jurisdiction over me, and if you have a complaint against me, you take it to them, and the only difference is they're going to make you swear to it. You need to know your denial of proper persona is considered enslavement within the jurisdiction of the International Criminal Court and a crime against humanity. You need to know complaints of human rights violations are submitted to the United Nations Human Rights Council. When the state is unable or unwilling to prosecute, you need to know last name, first name is a legal fiction, not propria persona, and its use in court case to identify a person is a crime against humanity and will be reported to the United Nations Human Rights Council. Already did it. You need to know a Catholic sister is a victim of human rights violation in a case being heard by someone unauthorized to practice law and usurping the powers of a judge. Prosecuted by individuals claiming to be Kane County State's attorney and deputies, but not in the name found on the roll of attorney, and therefore not in their official capacity, but as an unauthorized transgressor, using a form not authorized by the Conference of Chief Circuit Court Judges, resulting in direct criminal contempt of court, false personation, color of law, crimes against humanity, and far worse for their soul, their denial of the Holy Ghost. You don't want to do that, man. That's the one blasphemy that God won't forgive. You can blaspheme the Father, you can blaspheme the Son, but do not blaspheme the Holy Ghost. Jesus said so. Rosita is the victim in this example of daily persecution and denial of the Holy Ghost by members of your private society who have a duty to police their membership as sworn officers of the court. You need to know you are one of these sworn officers and God is watching. Case number 13 CM 3431. In any case is incorporated by reference, filed with the clerk of the Circuit Court, Kane County, Illinois, are simulated legal process and color of law and crimes against humanity. Propria persona, Rosita Staskovine, has been subjected to enforced disappearance of person and replaced with a legal fiction. You need to know that you are now an accessory to her persecution and your denial of the Holy Ghost within her if you do not come to her aid and right the wrong done under this case. A few unauthorized forms are attached as documentary evidence of the organized criminal activity surrounding case number 13CM 3431, and that should satisfy probable cause for an investigation and injunctive relief for Rosita. Pope Francis said organized criminals are excommunicated ipso facto by the fact that they're organized criminals. Allowing this crime against humanity to continue would make an individual accessory to an excommunicable event, an excommunicable sin. In other words, brother, you're excommunicated also. When the Metropolitan issues his formal decree for your excommunication, your propria persona will be erased from the book of life, and you will be banished into the world with no trace of your existence and begin your eternal torment. So stop and start righting the wrongs. And be of good cheer. Your sins are forgiven you. Go and sin no more. That's what Jesus said. That's why it's in red. Robert Allen Radusky, Office of Christ. Because Christ is an office. It's the anointed one. Been anointed, priest, prophet, and king makes you a Christ. And Jesus said, far more will come after him. So there you go. Right? I'm going to send this to a bunch of Catholic lawyers and play on their conscience. Make them aware. Now they can't say they don't know. They can't say they don't know that a lawyer's name on the roll will reflect the name under which the lawyer was admitted to practice law in Illinois and any subsequent name change allowed by the court. And if you're not using that name, I don't need to tell you. I just need to send it to the people that are over the unauthorized practice of law and see if they do something about it. Alrighty now then. That's all I got. And if you're still watching and found this useful, I really hope you can help me out. The PayPal account is ashleyratluski@gmail.com. Snail mail. So I can fulfill my mission. It's easier to do when my stomach's got something in it. Okay. Thanks a lot, everyone. We'll see you. Merry Christmas. Happy holidays. New Advent. The risen Lord is here. You don't know the hour of his coming.